Harvey has officially addressed her other quote-unquote victims of stalking after they have come out to speak out against her, and Netflix has used them as evidence against Fiona Harvey, if that makes sense. Anyway, let's have a look at what we've got. So over in the court documents, this is the final of the 3 court documents that were filed. So it was filed on the 26th of August 2024. As you can see, again, Richard Roth, Fiona Harvey plaintiff, defendants Netflix, all the rest of it. So the plaintiff's memorandum of the law to strike the declarations of Wray, Richard Gadd and Louise Oakley. So this is the plaintiff's motion to strike declarations of Wray, Richard Gadd and Louise Michelle Oakley. So obviously these are the people that have spoken out against her and have basically been used in Netflix's motion to strike. So she's basically spoken out against these people's, I guess their accounts of running into Fiona Harvey. So let's have a look at the introduction. So Fiona Harvey filed a straightforward defamation case against Netflix, asserting that it made false statements in the Netflix series The Baby Reindeer, the series about her. The complaint specifically alleges that the following statements by Netflix were false and defamatory. 1. Harvey was a twice convicted criminal who served 5 years in prison. 2. Harvey S.A'd Richard Gadd by grabbing his penis until he beated. 3. Harvey violently attacked Richard Gadd by gouging out his eyes with her thumbs and by smashing a glass over his head. 4. Harvey waited outside of Richard Gadd's house for 16 hours a day. 5. Harvey stalked a police officer. The defamatory statements. So, in its motion to strike a pursuant to California's anti-SLAPP statute, Netflix does not dispute that none of these events actually happened. Netflix even admitted to the UK Parliament that the person whom the base would show, Harvey, had not been convicted of a crime. See the declaration of Brian S. Levinson on the opposition motion to strike. Nonetheless, the support of its motion to strike, Netflix has submitted 2 declarations from Richard Gadd and Wray that are not relevant but deeply impertinent and scandalous. Netflix has also submitted a declaration of Louise Michelle Oakley, a barrister in the UK who has offered their opinion that there was sufficient evidence to provide a realistic prospect of conviction of plaintiff of stalking, punishable by up to 8 years in prison based on the conduct that occurred over 20 years ago. The court should strike each of these declarations and not consider them on the defendant's motion to strike. The declaration of Wray is not relevant because none of the events or conduct described by Ray's declaration or the exhibits thereto, all of which took place over 20 years ago in referenced in the complaint or even in Baby Reindeer series itself. The Wray declaration does not make any of the undisputed facts at issue more or less probable, nor could they, since Netflix concedes that the false statements at issue in the series are fictional. Further, Wray's declaration of irrelevant facts and exhibits relate to her experience with Harvey, which does not form any part of the complaint. Accordingly, the Wray declaration should be struck entirely, and Wray should be precluded from testifying at trial. Okay, so it's very interesting to see how this is playing out. Obviously, they don't want Wray to be testifying in court. They're saying that she shouldn't have a voice. She doesn't deserve to be heard because she's practically irrelevant to the case. And everything that took place, none of it's relevant. Regardless of whether it did or didn't happen, in this case, irrelevant. The declaration of Richard Gadd is equally irrelevant, impertinent, and scandalous. Gadd does not dispute that Netflix's statements about Harvey are false. Instead, Gadd denies that Harvey is Martha and claims that the series is fictionalized. This is where Gadd's declaration ceases to have any bearing on Netflix's motion to strike. From that point on, in what we can fairly describe as a scorched earth litigation, Gadd describes in detail over the course of 17 pages his real-life experiences with Fiona Harvey and unloads what he claims are 60 real emails, messages and letters from Fiona Harvey that are at all times irrelevant, impertinent and scandalous. As an initial matter, if Harvey is not Martha, as Gadd insists, then there is no relevance in Gadd's thoroughly documenting of his real-life experiences with Fiona Harvey, but more baffling is how Gadd can claim under oath that Harvey is not Martha when every interaction Gadd recalls about Harvey is identically attributed to Martha in the series. So, yes, I agree with that sentiment. But does that not also kind of like work on the flip side, where basically Fiona Harvey has stated that she wasn't Martha, as she said in the Piers Morgan interview, which she denied under oath as well in her letter to court. But does that not mean that you're admitting that she is Martha? Because that behaviour truly did happen. I'm confused. Anyway, regardless of the other Exhibit 44, which confirms Harvey did not wait outside Gadd's home for 16 hours per day because Harvey did not know where Gadd lived, not one of Gadd's exhibits 1 to 60 relates to Netflix's defamatory statements or Harvey's complaint, and all the exhibits are scandalous and prejudicial with no relevance. They purport that Harvey's sexual explicit messages to Gadd or emails that include racist remarks by Harvey does not concede that these are authentic, given all the lying that is already documented in this case. So she's saying that these are fake emails. She's saying that she can't confirm that these are real or not. Wow. So basically, because they call out racist remarks, and it basically highlights racist remarks, she's not going to state that categorically that was her. Holy shit. And the fact that the discovery has not commenced to native files have not been produced, but even if these emails are legitimate, they do not make any fact concerning Harvey's defamation claims more or less probable. As Netflix concedes, Gadd's exhibits were awash with violent hate speech and sexually explicit, deeply disturbing virtual that is nowhere depicted in the series. So, yeah, they weren't depicted in the series, but at the same time, like, they carry weight, surely. Surely these messages and emails carry weight, and that's why they're probably trying to get them struck out of the case. Because if you take this to a jury, and a jury sees Fiona Harvey's alleged behaviour in the series, and then you see Fiona Harvey's actual behaviour in the emails, you can probably put two and two together and be like, well, if she went this far with the emails, who's to say she didn't go as far as what they're claiming in the series? Might be the reason why they're trying to get it struck out. Where are we? Accordingly, paragraphs 23 to 65 of Gadd's declaration and exhibits of 1 to 60 thereto should be struck, except for the last sentence of paragraph 41 and exhibit 44, which confirm that Harvey did not wait outside of Gadd's home for 16 hours per day because Harvey did not know where Gadd lived. So basically they're just cherry picking from the emails. But again, if they're going to claim that the emails are, like, Fiona Harvey does not concede that these are legitimate emails because of all the lying that's taken place thus far. So you can't just cherry pick. You can't say, like, oh, we don't want these emails included within the case because they're irrelevant and we can't confirm their authenticity. But we'll keep that part that does confirm and back up our case. That does surely no, it doesn't work like that. You can't cherry pick what you do and don't want from fake emails when you've outright said fake emails, basically. Like, they're alluding to the fact that Netflix have created these emails and, you know, whatever. And it's unsurprising that Fiona Harvey has turned around and said, yeah, they're not real. But at the same time, you can't then say, but I want all of these struck out of the case, but from these fake emails, let's keep that part, because that part's relevant to our case. No, like, you can't do that. If you're going to strike them all, strike them all. If you're going to keep them all. Anyway, finally, Netflix offers the declaration of Louise Michelle Oakley, a barrister in the UK who has been hired by an expert by defendants to offer the opinion that there was sufficient evidence to provide a realistic prospect of conviction of the plaintiff of stalking punishable by up to 8 years in prison based on the conduct that occurred over 20 years ago. Netflix cites no authority that would support the consideration of an expert's opinion that someone could hypothetically have been convicted of a crime based on the set of assumed facts. Based on Oakley's hypothetical conviction of Harvey, Netflix argues that the defamatory statements are thus non-actionable as they are substantially true. Defendant's brief, part 14, the Oakley Declaration is unduly speculative and should be struck. So background, we go on to talk about the Baby Reindeer, the series. We don't need to talk about all that stuff because we know so much about it. But what we do care about is further down where it says, A, Laura Wray's declaration. So the Wray Declaration detailed an anecdote about Harvey's employment with her law firm in 1997 that caused Wray to terminate Harvey. Following Wray's decision to terminate Harvey, Wray claims that Harvey harassed and stalked Wray and her husband, who was a member of parliament, and Wray states that they communicated her concerns about Harvey to the Law Society of Scotland. Harvey continued to harass with calls and letters, and Wray again expressed her concerns to the Law Society. Wray claims that Harvey made false reports to the authorities about Wray mistreating their developmentally disabled son. Wray contacted the police on several occasions between 1997 and 2002, but they took no action. Wray obtained an interim interdict, a temporary restraining order, in 2002. Wray states that she did not hear from Harvey after 2002 until Baby Reindeer was released in April 2024. Wray claims that Harvey stalked other politicians, and Wray provides 16 exhibits of primarily consisting of her correspondence in the late 1990s with the Law Society, another law firm, interim interdict, and articles about Wray's allegations of being stalked by Harvey. Okay, so is that just highlighting her declaration? There's no admission there's no admission or stating that this definitely didn't happen within this one, so that's interesting. Maybe that will come later. Richard Gadd's declaration. The Gadd Declaration provides details on his professional accomplishments. In his declaration, Gadd describes Baby Reindeer series as based on real life events, and he created a fictionalized characters including Martha, and that he used his real life experiences to craft the Martha character. Gadd claims Martha is a fictional character, and that he did not write the series as a representation of actual facts about any real person, including Fiona Harvey. Notwithstanding Gadd's statements that Martha is fictional and Martha is not Fiona Harvey, Gadd inexplicably writes 17 pages of details about his real-life experiences with Fiona Harvey under the section heading Real-Life Experiences with Fiona Harvey that serve no purpose other than to publicly humiliate Harvey. Gadd's real-life experiences with Harvey are depicted note for note in Baby Reindeer as Martha. These experiences include meeting Harvey at the pub where Gadd worked, offering her a cup of tea on the house, engaging in banter, discussing their common Scottish heritage. Gadd states that after their first meeting, Harvey stalked and harassed Gadd by frequently appearing at the pub, including arriving at the pub before his shift started and interjecting as Gadd tries to serve tables. Gadd states that when Harvey once mentioned to a customer about a bad review on his comedy show, Gadd recalls that Harvey went to his comedy shows. In addition, Gadd states that Harvey emailed him relentlessly throughout all hours of the day and night, and that Harvey sent hundreds of voicemails. However, these initial 23 paragraphs, Gadd's declaration takes a sharp turn. Declarations are Gadd's explanations of Exhibit 1 through 60 that he annexed to the declaration. Exhibits 1 to 60 are emails and letters that Gadd claims Harvey sent to him between 2015 and 2017, which frequently contained hateful speech and derogatory, racist and homophobic language. Gadd includes emails purportedly from Harvey to support his statement that Harvey is a hateful racist and homophobe who threatened him. Gadd includes emails to support his statement that Harvey regularly propositioned him with lewd and explicit language. Gadd includes his emails with the police about Harvey, and Gadd provides an angry voicemails that Harvey left for Gadd. Unfortunately, I haven't heard these voicemails. I really want to, but they haven't been released to the public. Well, they have been released as exhibits, but we are not able to, from the public, able to hear them. Paragraphs 57 through 65 of Gadd's declaration explain the contents of Harvey's purported emails concerning Harvey's problems with her sister and trust and estate law firm and politicians. Okay, so I'm assuming this is just outlining what each person said. So Louise Michelle Oakley's declaration. Louise Michelle Oakley's declaration provides detail on her professional accomplishments. In her declaration, Oakley explains the background regarding the criminal stalking laws in the United Kingdom and how such cases are prosecuted. Oakley then lists the material that she reviewed, and while conceding that it is not her function to decide whether the person is guilty of a criminal offence, she offers her opinion that the plaintiff pursued a course of conduct towards Richard Gadd that amounted to stalking, and that there was sufficient evidence to provide a realistic prospect of the conviction in respect of the least one charge of stalking, and that plaintiff's alleged unwanted sexual touching is capable of amounting to SA. Having convicted plaintiff of hypothetical stalking and sexual offences, Oakley then leaves her self-appointed roles of prosecutor and trial jury and wraps herself in the judge's robe and perhaps a wig for sentencing. She classifies that the hypothetical stalking offences as a Category 1, the highest level offence, and pronounced that 5 years imprisonment with the category range of 3.5 year to 8 year custody. That would be the starting point. As for the SA charge, Oakley opines that plaintiff did not commit one sexual offence. She committed multiple incidents, and decides that the factor of sentencing council guidelines do not adequately reflect the culpability of Fiona Harvey and all the harm caused to Richard Gadd. Based on these findings, Oakley bangs the gavel and declares that the plaintiff's conduct passes the custody threshold as a sentence for up to 2 to 3 years and may be appropriate for SA. The Oakley declaration is silent as to whether the plaintiff's imaginary prison sentences will run consecutively or concurrently. Wow, okay, so interesting stuff. Legal standard. Courts have inherently authority to strike improper filings, particularly where document is immaterial, impertinent, or scandalous. Okay, so this is basically the legal standing on these declarations. So the argument: the pure irrelevance of Laura Wray's declaration is evident that Netflix only makes 2 passing references to the declaration of its memorandum of law to repeat Wray's scandalous claims that in the late 1990s Harvey stalked Wray and made death threats against Wray and her husband, and made false reports to the authorities that the couple mistreated the developmentally disabled child. What do these facts have anything to do with Netflix false claims about Harvey with respect to Gadd? That she was convicted for stalking Gadd, arred him and attacked him, or waited outside his home? Nothing. Wray's evidence has no relevance to any of Harvey's claims of defamation against Netflix concerning Richard Gadd in Baby Reindeer, in that these statements do not make it more likely that Harvey was convicted. Harvey had spent 5 years in prison, including 6 months for crimes related to harassing Gadd, awed Gadd by grabbing his penis in the dark alley until he beat it, gouged Gadd's eyes out with her thumbs and smashed a glass over his head, waited outside Gadd's home for 16 hours a day for him, or stalked a police officer. Even if Wray's statements are true, none of Wray's statements makes any of Harvey's defamation claims less likely to be proven. In light of Netflix and Gadd's admissions to Baby Reindeer is fictionalized, and their failure to claim that any of the specific conduct attributed to Harvey, that it is the subject of complaint, is actually true, as Netflix comfortably represented to 50 million people. It is clear that the sole purpose of Netflix's filing for Wray's declaration is to provide scandalous and impertinent and compelling information about Harvey to its subscribers. Wray's declaration must be struck entirely. Richard Gadd's declaration. With the exception of his last sentence in paragraph 41, paragraphs 24 through 65 of Gadd's declaration have no relevance to Harvey's claims. Likewise, with the exception of Exhibit 44, Exhibits 1 through 60 that Gadd includes in his declaration are not relevant to Harvey's claim. Gadd states that he is providing a purported emails from Harvey to show that Harvey is a hateful racist and a homophobe who propositioned him and lewd and explicit language. This is plainly impertinent, scandalous, and not relevant to the Harvey's claims. Gadd's statement have no bearing on whether Netflix's statement that Harvey was convicted, grabbed Gadd's penis until he beat, all the rest of it. False claims about Harvey. Throughout his 21-page declaration, Gadd does not dispute any of this conduct is made up by Netflix. In fact, Gadd confirms that it is a fictionalized story. Netflix itself admits that Gadd's exhibits 3 through 41 are awash with violent hate speech and sexually explicit, deeply disturbing virtual that is nowhere depicted in the series. Plainly, material that is nowhere depicted in the series cannot be relevant to the claims in the case. Accordingly, paragraphs 24 through 65 and all the rest of it should be struck from the case. Right, as for Michelle Oakley, or Louise Oakley, there is no question that the plaintiff was never convicted of any crime, much less any of the crimes in which the Martha character was convicted in Baby Reindeer. Defendants wish to argue that the plaintiff could have been convicted based on the conduct alleged by Gadd's declaration and is based on the opinions of their legal expert, Louise Michelle Oakley. The Oakley declaration should be excluded for several reasons. First, the defendant has failed to comply with notice requirements for the rule. Second, under Rule 702 of the Federal Rules of Evidence and the decision of all the rest of it, because it's neither relevant or reliable. Oh, I need a drink. Okay, so these are the several reasons why it should be struck out. We're going to skip through it because it's just kind of citing other cases and all the rest of it. So let's skip to the conclusion. The court should strike Laura Wray's declaration, all exhibits thereto in their entirety, from the motion to strike, and preclude Laura Wray from testifying at trial. In addition, the court should strike paragraphs 24 through 65 of Richard Gadd's declaration, exhibit, and accept the one part that they want to keep in, which again, I just find that really weird. If you're going to strike it, if you're going to state that it's irrelevant and it's not true, I mean, Harvey's apparently said that it's not true, so therefore none of it should have any standing, but because it stands, in line with your narrative, of course you want to keep it in. From the motion to strike, finally, the court should strike the declaration of LMO, I just can't be asked to say the whole name again, in its entirety from the motion to strike record. Dated August 26, 2024, respectfully submitted by Brian Levinson, obviously from the Roth Law Firm. Oh, that was a lot of reading once again. So, again, the motion to strike has... I don't know if there's been any kind of response from the courts regarding this. I'll look into it. But that's everything from Fiona Harvey's lawyers. So we've heard from her lawyers specifically, about the motion to strike. We've heard from Fiona Harvey specifically, and we've heard about Laura Wray and everyone else who testified against her. If you haven't seen the last two videos, that kind of goes over in detail the recent accounts and, the other documents that were filed, but this is getting spicy. What do you guys think, though? Let me know your thoughts and opinions down in the comments below. While you're down there, be sure to jump to get the hell out of that like button, and until next time, I'll speak to you later. Peace.